Okay, item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by Municipal Operations LLC for new TIPD's permit number WQ 00161710001. Today we have, as a courtesy to the legislature, the commission allows remarks from legislators and statewide elected officials. And today we have a member of the legislature is asked to address the commission. As a reminder to the commission, the decision today must be based on the administrative record and the arguments of parties. But with that, we'll call Representative DeRazio. I'm so sorry to interrupt, but there's a green light, a little button to push.
Can you hear me now? Okay.
Thank you.
I appreciate the opportunity to speak with you today. You know, being the first individual up, I feel like I'm pushed through the door. I've gone through the door on somebody else's push. So I appreciate that. And I want to thank you for allowing me the privilege to speak. Simply put, the proposed wastewater treatment facility is a serious risk to the well-being of anyone who relies on the Edwards Aquifer or the Trinity Glen-Rose Aquifer. My team and I have studied this proposal starting back in early 2023. I have talked to city, state, and county leaders. I've spoken to Republicans and Democrats. I've spoken to scientists, businessmen, homeowners. I've met with Lennar, and I've met with residents along the Helotes Creek. Through all of that, I keep coming up to the same conclusion. This wastewater treatment plant is unwise. I don't know how many times a legislator discussed the scarcity of water to my 2 terms here, but it's been enough to make one message very clear. We've got to be careful. Texas is a growing state, and that's wonderful. Our success has been driven growth, and that growth will continue to fuel our success. But if we don't grow intelligently, and we're not good stewards of the resources entrusted to us by God, that growth and success will not last forever. Here's a simple fact. This treatment plant will dump wastewater into the creek used by the locals for recreation and by Bexar County and much of central and southern Texas for drinking water. I'm sure we'll hear it many times today, but it bears repeating. The Helotes Creek watershed represents 15% of the Edwards Aquifer recharge zone. And if you do the numbers, you have 600,000 acres. Divide that by 15, and that's roughly about, 90,000 acres of the recharge there. If we're not 100% certain that the treatment plant won't threaten that wonder of the natural world, we must deny this permit. And unfortunately, we cannot be 100% certain that it will not threaten our water, even when this facility is working perfectly. There will be pharmaceuticals in the water at levels that will be impossible to predict or control. Those pharmaceuticals will have an impact, whether we like it or not, on wildlife, on people who will go to drink the water. You know, as with any man-made invention, there will be days when the facility is not 100% compliant with the TCEQ standards. People make mistakes, accidents happen. On days when this plant is not working at peak efficiency, there'll be human waste poured directly into our water supply. And the TCEQ cannot estimate how many days of this dumping that the aquifer can take before they're permanently damaged. I don't stand alone in my concern over this project. Every single member of the Bexar County House delegation signed onto a letter this summer calling on the TCEQ to reject this permit. They represent people from the rural areas, the suburbs, and the inner city. That group includes some of the most progressive and some of the most conservative members of the House. But they all agreed when looking at the evidence, this wastewater plant is too risky. Before I go, I want to recognize the tireless efforts of the people from my district who have organized a respectful and informative campaign. They've been so kind to me and my staff and have made thousands of people from around the state care about an issue that would have been ignored in most communities. I commend them for their actions. And in closing, I ask you to seriously consider reversing the course to keep our water safe. And I trust your judgment in how you will make this happen. Thank you very much.
Thank you, Representative. I appreciate your comments.
Okay, that will bring us to the parties' presentations. The applicant, Municipal Operations LLC, should speak first, followed by aligned protestants, the ED, and then OPIC. Parties were notified of the following times for oral argument. Applicant, 8 minutes. Protestants, collectively 8 minutes. The ED, 5 minutes, and OPIC, 5 minutes. The applicant may reserve time for rebuttal as it bears the burden of proof on the application. And we have Ms. Helen Gilbert here for the applicant.
Good morning, Chairwoman,
Morning.
Commissioners, General Counsel. My name is Helen Gilbert. On behalf of applicant Municipal Operations LLC, before I get started, I'd like to reserve a little time at the end, if I have some, to respond. We are pleased to be here today in support of the proposal for decision. The ALJs did a thorough job analyzing this case on the facts and on the evidence and recommending issuance of the permit. Of course, we hope you will agree. For over 3.5 years, this permit application has been poked, prodded, and scrutinized at practically every level: state, county, as you just heard, city, micro city, and if you believe the TikTokers, even at the international level. But this permit meets and exceeds applicable rules and statutes. It is not a serious risk, as you just heard. With all due respect, the protestants and Representative D'Orazio have not looked at the evidence. What they share, however, is that they collectively ignore the fact that this site will beneficially reuse 100% of the highly treated wastewater. So the outrage that there will be 1 million gallons per day of raw sewage dumped into the Edwards Aquifer is simply patently false. On reuse, we understand that you have to have a discharge permit as well as the Chapter 210 reuse authorization in the case of rain or saturation. But in this case, there is a utility service agreement. This is part of the application, Exhibit 1, that, by the way, SAS, who does not oppose this application and who is the water provider, requires half of the 1,100-acre footprint to be reserved for green space. That allows significant opportunity for storage and irrigation. This means that the site will not be discharging most of the time, furthering water conservation in a major way. This was not lost on the ALJs, who thought it was important enough to mention on page 1 of their PFD. The site will also employ a Class A operator, which is not required, and it cannot expand the capacity for the life of the project. I want to briefly address the 4 remaining issues that were not dismissed at summary disposition: surface water, groundwater, endangered species, and regionalization. On surface water, the effluent set is a 552.15. That's one of the lowest total phosphorus limits in the state of Texas. Protestants urge the Liberty Hill limit and anything lower because, well, they do that in Breckenridge, Colorado. Your nutrient screening process is not a one-size-fits-all. It is very site-specific. It's based on the characteristics of this site, like tree canopy in the substrata of the Helotes Creek. I know this comes up in a lot of cases, but there is not a Liberty Hill standard. We are over 100 miles away in a different county, in a different watershed, and in a different dry creek system with the Helotes. What also comes up a lot, and what the protestants urge here, is that you throw out the uncalibrated Qualtex model because it uses default coefficients. There's no basis to do that. This is part of the implementation procedures, and you rely on this system statewide. The permit also exceeds the Edwards Aquifer rules in Chapter 213. These rules expressly allow the discharge of treated wastewater on the contributing zone. The protestants would have you treat the contributing zone like the recharge zone. But again, there's no basis to do that, certainly without notice and due process and a rulemaking. These rules apply in 8 counties to hundreds of dischargers. So again, there's no reason to bypass the Edwards Aquifer rules, which we exceed. The rules set forth in the Edwards rules are a 5521. And again, we're at a 0.15, which is dramatically lower. On the issue of burden of proof, this is another area where the protestants would change the rules to fit their argument and jettison the Senate Bill 709 standard, where you must demonstrate a violation of applicable state or federal rule in order to rebut the prima facie case. They would substitute that with something called reasonable potentiality. That's not the standard. You've categorically rejected that before. Madam Chairwoman, I believe you addressed that in the environmental park municipal solid waste landfill case, and we would urge you to do that again today. As to groundwater, finally, again, this commission has chosen to deal with that through the Edwards Aquifer rules in Chapter 213. If and when this plant even discharges at all, it flows for a mile before it exits the property. So it's well over 250 feet away from private wells and 500 feet away from any public wells. Matter of fact, the city of Gray Forest public well is over 2.2 miles away. There's also a confining layer. You don't hear much about that from protestants between the upper and middle Trinity, where all the wells in this area are completed. So there's no pathway for contamination. Finally, it's been a longstanding policy of this commission. I think in the Undine case that you decided recently, the policy that if surface water is protected, then groundwater will be protected also is something that you should uphold here. So there are at least 3 ways where groundwater is protected in this case. And of course, again, reuse, we can't lose sight of that. As to endangered species, in short, there are no aquatic or aquatic dependent species here. For the non-aquatic species, karst invertebrates, or what we call cave bugs, there's no critical habitat on this site, and the only critical habitat nearby is 2.7 miles away. I'm sorry, is that it? 1 minute. Oh, thank you. Finally, regionalization. This was sort of an argument like PFAS that the protestants jettisoned along the way, but there was a really interesting exchange about regionalization that I want to end with, and that's statements by the mayor of Gray Forest, who did not say there is no need for this treatment plant. And by the way, we can't connect with anyone because the only plant with capacity is 17 miles away. But he said there's no need for this development. In other words, there's no need for homes. We know that that's not the standard. And what he's really espousing is a land use argument that's outside of the jurisdiction of this commission. So we support the PFD. We request that you issue the permit, and I'm happy to answer any questions you might have.
Thank you, Ms. Gilbert. We'll hear from the protestants, please.
Good morning, Chair, Commission. My name is Lauren Ice. I'm an attorney here on behalf of the Greater Edwards Aquifer Alliance and also the City of Gray Forest. And with me is Eric Allman, lead counsel on the case. I'm going to spend just a couple of minutes addressing the issue of the dissolved oxygen modeling, and then Mr. Allman's going to use the remaining time to address the remaining issues and also lay out some more of the facts that you heard Ms. Gilbert speak to earlier. Dissolved oxygen, or DO, is one of the few pollutants for which TCEQ has set numeric limits. Setting aside the issue of whether the receiving streams were properly classified, One of the primary issues in dispute in this matter is whether the 3.0 milligram per liter dissolved oxygen criteria, which was established by the ED, will be achieved downstream of the discharge point in Helotes Creek. And the Qualtex model says that it will not, that actually dissolved oxygen will drop below 3.0 to 2.9 milligrams per liter. Now, the PFD makes two primary errors when it comes to this issue. Both are misapplications of the burden of proof. And they both have to do with the applicant relying on, one, the uncalibrated model, and two, this margin of safety. And as an initial matter, I would like to say to the dais of attorneys here that the margin of safety, as it's been applied here, has no basis in law. It amounts to an ad hoc rulemaking. It's in violation of Chapter 26 of the Texas Water Code, and it's not been approved by EPA. So there's no basis to supersede this 3.0 milligrams per liter criteria that was set by the ED. And the applicant, importantly, has provided no basis that the margin of error is reliable here, given the circumstances. Now, protestants' evidence shows that the uncalibrated model's default parameters are wrong. Other experts agree with this, and as a result, the model likely overpredicts dissolved oxygen. Thus, the model is not conservative. This takes away the rationale for applying or relying on the margin of safety, which can only be applied in conservative circumstances. So protestants do not have the burden of proof on this matter. We have the burden of production, meaning we have the burden to present evidence that raises a genuine issue of material fact to whether the permit is going to meet the 3.0 milligram per liter numeric criteria. And that is something the protestants have done. We are not arguing, as Ms. Gilbert suggests, to simply throw out the Qualtex model because it is uncalibrated, but the applicant has the burden of proof to show, despite the inaccuracies, that the model is nevertheless reliable to determine that dissolved oxygen will not be violated. And rather than present evidence that demonstrates that the model's results are reliable, the applicant simply points to the fact that these default parameters and this margin of safety have been used elsewhere in other permitting matters. But in doing so, the applicant really highlights the nature of the error, which is just because it could have been reliable in other situations, applying other site-specific circumstances, like Ms. Gilbert pointed out, is important to apply. That does not mean that it is reliable here, nor does it relieve the applicant of their burden to show that it is reliable. And so without the evidence supporting that conclusion otherwise, the permit should be denied on this basis alone. And I'll reserve the remainder of my time for Mr. Allman. Thank you.
Thank you.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. This is a case where you look at the relevant facts and the relevant law. It demonstrates the permit must be denied.
Mr. Allman, can you check and make sure the light's on?
The green light?
Is it on?
Yes, it is. I speak quietly. I will try as hard as I can.
Yeah, sorry.
I'll decline, I admit to. So the relevant facts and the relevant law require denial of this application. Let's review the facts a bit. This is located upon a piece of property with karstic features, meaning that there are connections to the groundwater where the water will move very quickly without much dilution. Shortly more than a mile downstream, this reaches Helotes Creek, which is used for both swimming and fishing, and is perennial. It is a central feature of the city of Great Forest. There's a park up and down along it. The public uses it much for both swimming and fishing. Now, let me speak first to anti-degradation. The difference between this case and whatever landfill case was referred to is your rules in Chapter 305, as required as a condition of your MPDS delegation, say that every draft permit must include conditions which ensure that the permit will not cause or contribute to the violation of water quality standards. That's in your rule. That's not a change to the burden of proof. Now, in this case, the Tier 1 review is protect existing and attainable uses. Helotes Creek is used for swimming and is actually used for fishing. And yet the standard applied to Helotes Creek is not appropriate for the protection of those uses. In that way, the Tier 1 standard of your rules is violated by issuance of this permit. In addition, Helotes Creek, because it is fishable, swimmable, should have been subject to a Tier 2 review to determine whether the degradation was necessary for important social or economic development. That was not applied. No Tier 2 review was performed on Helotes Creek. Again, this is important. This distinguishes this case from the Save Our Springs Alliance case, which was one where a Tier 2 review was performed. The question was it adequate or not? Here, there simply was no review for that particular requirement of your rules. In addition, the Supreme Court made clear that a Tier 2 review requires a review of the whole water body and the interaction between various contaminants. No type of review such as that was performed for any water body here. And certainly, let me move on to groundwater issues. This is within the contributing zone to the Edwards Aquifer, but it's located in an area over the Trinity where the karstic features do create a connection between the surface water and the groundwater. There's been talk that you have a policy that the protection of surface water is adequate to protect groundwater. We confuse the word policy. You are required to embody your general policies within rule, and you may only treat those as general policies. Nowhere in your rules does it say the protection of surface water is adequate to protect groundwater. In fact, in this case, that is not the case. A central concern for groundwater is nitrate contamination. Phosphorus is your main concern for nutrients in surface water. For that reason, the draft permit contains no limit whatsoever for nitrates, which prevents it from actually protecting groundwater. And I'll divert to a procedural issue. In this case, a deposition was taken of the Edwards Aquifer Authority in which the applicant's counsel engaged in harassing questioning of the witness. The ALJ excluded that testimony based on that fact that occurred from the applicant's attorney. There's no precedent for excluding evidence due to an act by the applicant and imposing a discovery sanction upon the protestants. I say that because, of course, it won't be the ALJ to defend that decision in court. It will be your job to defend that decision in court, which influenced the findings of fact in this matter. Wildlife has not been protected. There are karst invertebrates potentially present on site. The applicant's own expert said you need to do more investigation into that. It wasn't performed. The applicant's expert on wildlife could not even at hearing identify where the discharge point is in relation to those features. We said, is it down at the southern end of the property or is it the northern end? He did not know. He couldn't point to where it was located. He simply did not perform the type of analysis to ensure the protection of wildlife in this case. In addition, the nutrient screening was not adequate. The implementation procedures direct a nutrient screen for a full 15 miles downstream of the discharge. That was not performed in this case. They also say that the presence of perennial poles can increase the concern for eutrophication impact.
That's time.
That was not considered in this case. We ask that you deny this permit as is required by the relevant facts and the relevant rules. Thank you very much. I'm available for any questions you may have.
Thank you very much. Appreciate you. We'll hear from the executive director staff, please.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Fernando Salazar Martinez of the Environmental Law Division representing the Executive Director. With me today from the Water Quality Division is Peter Schaefer, Team Leader of the Standards Implementation Team, Orlando Vasquez, a Water Quality Modeler in the Water Quality Assessment Team, and other technical staff from Water Quality Division. The Executive Director recommends the Commission adopt the Administrative Law Judge's proposal for decision and proposed order as revised by the ALJs in their exceptions letter and issue the draft permit without changes. The Executive Director agrees with the Administrative Law Judge's findings of fact and conclusions of law as referenced in their PFD on referred issues A through G. Prior to the hearing on the merits, the ALJs granted the applicant's motion for partial summary judgment on issues C, E, and F. As for the remaining referred issues, after the hearing and examining the evidence in the record, the ALJs found that the draft permit is adequately protective of water quality, including surface water, groundwater, and drinking water wells, that the draft permit is protective of wildlife, including endangered species, in accordance with the Texas Surface Water Quality Standards and 30 Texas Administrative Code, Chapter 307, that the draft permit complies with siting requirements regarding floodplains and wetlands in accordance with 30 Texas Administrative Code, Chapter 309, and that the Commission should not deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code, Section 26.0282, and the general policy to promote regional and area-wide systems under Texas Water Code, Section 26.081. Regarding referred issue A concerning water quality, the ALJs found that the ED followed the agency standard procedures in using default parameters for the Qualtex model because substantial site-specific data is unavailable for the receiving water body, that the draft permit's total phosphorus limit of 0.15 milligrams per liter is justified based on the site characteristics and is sufficiently protective to preclude excessive growth of aquatic vegetation, that the ED's aquatic life use designations for the dissolved oxygen modeling and anti-degradation review were appropriate, and that the applicant met its burden to show surface water, groundwater, and drinking water will be protected under the terms of the draft permit. Regarding referred issue B concerning protectiveness of wildlife, the ALJs found that the applicant met its burden to show that the draft permit is sufficiently protective. Further, the ALJs disagreed with protestants' arguments that the draft permit's lack of limits for contaminants of emerging concern, PFAS, or similar constituents in the draft permit would justify denial of the permit. In conclusion, the executive director respectfully requests that the commission adopt the ALJ's PFD with the revisions referenced in their acceptance letter and issue the draft permit without changes. Thank you, and we're available for any questions.
Thank you, Fernando. Appreciate you. OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, and the Executive Director's Attorney and staff. For the record, I'm Pranjal Mehta with the Office of Public Interest Counsel. We have considered the evidence and arguments raised in this matter, and we respectfully offer our recommendation against issuing the draft permit, or in the alternative, remanding the matter to the ED for further evaluation. As stated in OPIC's closing brief, the applicant has demonstrated compliance on several referred issues, including siting requirements for floodplains and wetlands, as well as considerations of need and regionalization. However, the applicant did not meet its burden regarding protections for water quality and wildlife, particularly related to the proposed total phosphorus limit of 0.15 milligrams per liter. The record includes expert testimony showing that this phosphorus limit is at least 7 times higher than the existing concentrations in Helotes Creek, potentially causing more than de minimis degradation and excess algae growth harmful to aquatic life. This is especially concerning in Texas Hill Country streams like Helotes Creek, where species have adapted to low phosphorus environments. For protestants' concerns regarding groundwater protection under Issue A, we find the evidence was not sufficient to rebut the presumption of adequacy, as there was no clear proof of hydraulic connections or potential impacts on wells in the Upper Trinity Aquifer. Similarly, while emerging contaminants like PFAS raise valid wildlife concerns under Issue B, there is no specific regulatory guidance to use them as a basis for denial. However, phosphorus-related degradation directly affects wildlife, since excess algae can disrupt habitats for endangered and sensitive species. Therefore, while the applicant has met its burden on some referred issues, the proposed phosphorus limit does not ensure protection of water quality and wildlife. Accordingly, we recommend that the Commission deny the draft permit or remand it for reassessment of a lower technology-based phosphorus limit to better protect existing uses and the ecological integrity of Helotes Creek and downstream waters. Thank you, and I'm happy to answer any questions.
Thank you very much. Ms. Gilbert, I know you said you were going to reserve time. You are out of time. I'm sorry. All right. We have a proposal for decision before us concerning an application by Municipal Operations for a TIPD's permit to authorize a new wastewater treatment facility in Bexar County. The applicant intends to reuse 100% of the effluent, but a discharge permit is required for exigent circumstances. Excuse me. I've reviewed the record and the administrative law judge's analysis and recommendation to grant the permit. In my evaluation, I find that the evidence and record supports the ALJ's determination that the applicant met its burden to establish that the draft permit is protective and meets all applicable requirements. So I'd recommend adopting the ALJ's proposed order with one clarifying change to finding of fact number 2, which has been agreed to by the ALJs in their June 24th, 2025 reply to exceptions. I'll stop here and ask my colleagues. Commissioner Gonzalez.
I saw it the same way.
Commissioner Miller.
I agree that the record supports this.
Thank you. Do I have a motion?
I move that we adopt the ALJ's proposed order as revised by the ALJ's letter dated June 24, 2025, and issue the draft permit as recommended by the executive director and adopt the ED's response to comments.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you. We will take about a 5-minute recess to let people move in and out.